Welcome to our presentation for the 2020 Legal Writing Institute's Biennial Conference. Today we're going to talk to you about motions, memos, and messenger apps, a study of what new lawyers really write. I'm Rachel Goldberg, Assistant Clinical Professor of Law in Cornell Law School's lawyering program. My legal background is in criminal law. I was an appellate public defender for 6 years. I also have a PhD in rhetorical studies, and that background informed the design of our empirical study of new lawyers' writing practices.
And I'm Kelley-Widmer. I'm an Associate Clinical Professor of Law, also in Cornell's lawyering program. I practiced immigration law previously, and now I also teach an immigration clinic at Cornell. In working with budding lawyers on writing projects, both in lawyering and in clinic, from texting clients to massive legal briefs, I was really interested to see what new attorneys struggle with across genres and practice areas.
So in our many conversations about first-year lawyering pedagogy, Jack and I realized that we could best help our students prepare for workplace writing by figuring out what our students are actually being asked to do as new attorneys, what writing tasks they struggle with. So we designed a study addressing these two questions. What are the genres that new attorneys, which we defined as having 1 to 3 years of experience, most commonly write, and what are the most common writing problems that new attorneys encounter within those genres? So our presentation is based on our analysis of some of the questions we asked in that survey, and we can't cover nearly everything here, but by the end of the presentation, we hope you'll know what the most common genres and writing problems are for new attorneys, and we hope you'll come away with some ideas for empowering your students to confront the writing challenges they'll inevitably face in their first years of practicing law. So I'll tell you a bit about our survey methodology so you have some context for our analysis. In the summer of 2019, we sent a Qualtrics survey to about 6,600 attorneys, all of whom had some connection to Cornell. So they either graduated from Cornell undergrad and then went off to a different law school, or they graduated from Cornell Law School itself. And we received 745 complete responses to the survey. We first asked some quantitative questions. We asked a lot about demographics, such as practice location, type of practice, type of law, and so on. We also asked how often new attorneys composed particular legal genres. And we asked questions about how much feedback the new attorneys received on the genres they wrote most often. And the survey also had a qualitative component. So we asked open-ended questions about what writing issues new attorneys encountered when composing the genres that new attorneys most often write. Over the last year, we coded these open-ended qualitative responses using Atlas TI, and we analyzed the data using SPSS, which is a statistical software program. A quick overview of the demographic information so you have some context about our respondents. So 10% of the respondents were new attorneys themselves, that is with the 1 to 3 years of practice experience. 90% of the respondents were what we called experienced attorneys, that is with more than 3 years of experience. About half the respondents received their JDs from Cornell Law School. About half the respondents are litigators or work in litigation practice, 25% practice transactional law, and about 15% are in some kind of regulatory practice. And as far as their practice areas, about half the respondents practice in private or corporate law, about 16% in-house counsel. So together, the respondents skew pretty heavily towards the corporate law environment, but about a third of the respondents were in the government or public interest sphere. And this reflects the large number of Cornell graduates who completed the survey. They tend to go to big law firms in large urban areas. So keep those practice areas in mind when considering the survey responses. So I'll first give an overview of some of our quantitative results and discuss the most common writing genres, and then Jackie will discuss some of the most common writing issues and a couple of other patterns that we noticed. So we gave all of our respondents a long list of genres that we thought attorneys likely compose and asked them which out of this list new attorneys do actually write. And we created the genre list based on ABA materials, genres that are mentioned in legal writing textbooks and on the LWI listserv. We reached out to attorneys in various practice areas to make sure we weren't missing anything obvious. And in all, we gave respondents a list of 29 genres, and this is just a list of some that we thought new attorneys might write that you see here. Some of the 29, you can see that they range from formal to informal, PowerPoints, text messages, contracts, and so on, down to social media posts. If you're interested in seeing a list of all of the genres, you can reach out to us and we'll send you the list of the 29 that we asked about. And then we asked the respondents to note not just whether new attorneys write these genres, but how often they write them. So we gave them some choices: often, occasionally, rarely, and never. And we said that often meant that the new attorneys write these genres more than once a week. And we asked all of the respondents to identify the 3 genres that they actually write the most often. And these are the top 8 vote getters. They add up to more than 100% because respondents could pick more than one option. We asked them to pick 3. So as you can see here from the graph, almost 50% of the respondents said that new attorneys write informal emails most often. About a third said that new attorneys write emails summarizing legal findings to a client as one of their most common genres. About a quarter said that new attorneys write emails summarizing legal findings to a non-client, that is colleagues or supervisors, as one of their most common genres. 11% said new attorneys write contracts more often. 9% said new attorneys write formal or traditional memos to a non-client most often. And then you can see that a bit under 10% said that new attorneys write pleadings or discovery documents or trial motions most often. These top 8 genres accounted for about 80% of the most often composed genres. So there was a really steep drop off after these top 8. So they seem to capture really what new attorneys are most commonly writing. Jackie?
Thanks. So I'll turn now to some of the common writing issues that we discovered in these 8 common genres and beyond. So after asking our respondents to identify the common genres for new attorneys, we asked them a very open-ended set of questions. So our main open-ended question was, what kinds of issues do new attorneys struggle with when writing or communicating in the top genres you selected? Or what kinds of issues bother you or impede your working relationship? And then we gave some examples like underdeveloped legal analysis, arguments not supported, writing style issues, and things like that. And in addition, we asked respondents to provide examples of these common writing issues. Next slide, please. So given the open nature of our questions, we got a wide variety of responses in a narrative format like these examples. So you can see some themes as you read these examples, and you can tell here we've noted whether a new attorney gave this statement or whether it was an experienced attorney. You notice the new attorney says they have trouble succinctly stating complex ideas. Then you see right away an experienced attorney saying the writing is too verbose, and a little further down, the new attorney will forget that not everyone has the insight that they have gained after their research. So some themes that started jumping out at us right away were things like the writing needs to be more concise, the writing needs to be less repetitive, and the writing needs to be more tailored to the audience. This one, 4 bullets down, create a roadmap for the decision maker to follow. So as we reviewed the narrative responses, next slide please, we were able to identify 24 categories of substantive issues, which we've pictured here. And so we would read each response and code those responses by issues. Within these 24 issues that we identified, I have color-coded them here on this slide by clusters or sort of themes. So yellow you see is organization and conclusion, so organizational issues. The blue here is audience or style related issues. Green is analysis and similarly related issues. And then orange is mechanical type issues, grammar, proofreading, formatting. Next slide, please. So many people had comments like this one, which is all from one writer. I edited it into shorter paragraphs so you can read it, but essentially this person commented on many different issues, giving a more coherent picture of common ways that new lawyers struggle. And so we saw a lot of comments like these across all 8 genres or all genres. And so you'll see we've highlighted here yellow for an organization or conclusion issue. Green is for an analytical issue, like this person needs to present some key points to support their conclusion. And then blue, again, for audience here, and then for length and style. So this is how we analyzed the various narrative responses that we received to come up with what the most common writing issues are. Next slide, please. So these are the top 11 substantive problems in writing, and this is across genres and respondents, across practice areas, a level of experience, and everything. I was going to choose the top 10, but then I noticed that time management was very close to conclusion at 17.5 and 17% identifying those issues. And it was the only issue here in that orange category, mechanical or sort of non-substantive category, so I wanted to include it. But you'll notice here that there is a really steep drop-off between the top 4 and then the rest. So next slide, please. We'll focus in on our top 4 issues. All right, so you can see here that within the top 8 genres, these were the top issues, just in varying orders. So style, organization, concision, and analysis. These issues were flagged as a challenge for new attorneys by about 40% of respondents. Next slide, please. And interestingly, across the top 8 genres, these were the 4 major issues on almost all of those top 8 genres, but just in a different order. So, you can see here that style and concision are the top for informal email, and then organization and analysis. And then it's the reverse for that formal or traditional memo. It's first analysis and organization, then style and concision. And this makes sense because writers use different genres depending on their goals, and therefore their priorities are different depending on the genre that they're writing. But regardless of whether it's an informal email or a formal memo, these were our top 4 issues. Next slide, please. So interestingly, when we sorted answers by level of law experience, that is new attorneys with 1 to 3 years, or experienced attorneys at 4+ years, we found some disparity between what the new and the experienced attorneys think the problems are. Next slide, please. So, for example, experienced attorneys are more likely to find that new attorneys have problems with their analysis and their conclusions, whereas new attorneys are more likely to find that tailoring their content to the audience and giving the necessary background is really challenging for them. So these outcomes make a lot of sense given the differing experience levels. Experienced attorneys can spot those legal holes more easily, and new attorneys are just trying to figure out what's going on and tailoring that information for their audience. I'll turn it back to Rachel.
So another interesting disparity was the amount of feedback that new attorneys think they're getting on their writing. New attorneys, we found, consistently believe that they're getting much less feedback than experienced attorneys think that new attorneys are getting. So this graph shows you that disparity of just the top 4 most commonly written genres, but the pattern was actually consistent among all the genres we asked about. So if you look at the blue bars, you can see that's the percentage of new attorneys who say they are getting little or no feedback on writing the particular genre. So along the bottom, it lists the top 4 genres: informal email, email summarizing findings for client and non-client, and then contract. So you can see that most of the new attorneys who are writing these top 4 genres think they're getting very little or no feedback from their supervisors. But compare that to the orange bars. That's the experienced attorneys who say that they're that they are giving little feedback. So in other words, almost none of the experienced attorneys think they're giving little or no feedback. Almost none of them agree that new attorneys are getting little feedback on their writing. So experienced attorneys think that new lawyers receive much more feedback than new attorneys think they're getting. So I'll share with you some of the conclusions we reached based on the initial analysis of our data. So first, we already teach many of the genres that our students will end up writing as new attorneys. Recall that many new attorneys are most often composing the kind of legal analysis documents that we most often teach in first-year legal writing courses, like writing a summary of legal findings for clients or colleagues, or writing formal memos. And we already emphasize the major problem areas such as organization, analysis, style, tone, and so on. So given that we teach these genres and focus on the tricky writing areas already, why do new attorneys still struggle? We have some ideas based on our study, and of course there's already plenty out there on some of these issues, but our study helps add to the existing literature. So we found, like you just saw, that new attorneys need more guidance and feedback from their supervisor. So new attorneys don't leave law school as experts. They leave as informed novices who still need guidance on writing conventions and substantive law. But as we know from this study, there's a disconnect between the supervision that new attorneys think they're getting and what experienced attorneys think they're giving. New attorneys think they're getting minimal supervision, but they probably need much more active supervision. Another conclusion that we came to is that some of the writing problems require expertise that only come from practice. So the writing problems we coded in green, like analysis, framing, finding legally relevant precedent, are very context dependent and change radically depending on the area of law that the attorney is in. And these context dependent writing issues can't really be taught in writing programs at law schools because they rely on field expertise. A lot of the major writing issues that new attorneys are having are just inherent to a lack of experience. But, and this gets to the third bullet point here, it also seems like new attorneys don't deploy the knowledge they do have when writing in the genres that they know. So given that we do teach many of the genres that new lawyers write, and we focus on the issues that they struggle with, it appears that novice attorneys may not be recalling or using what they learned in their legal writing courses. Of course, we tell students that they need to write concisely and teach some version of CREAC and organizational structure and so on, but it appears that they don't deploy that knowledge, even when tasked with a writing genre that may be familiar from first-year legal writing. And we also see that new attorneys have trouble with these same issues like organization, tone, figuring out audience expectation when they're writing in new genres that we don't usually teach in first-year writing courses. But we don't, this isn't all discouraging news. Jackie's going to conclude with some of the ways that we can help our students when they encounter both old and new genres in practice. Jackie?
Thanks, Rachel. So yes, moving forward, now that we have discussed the results of our study and these conclusions that we've drawn, now let's talk about what and how we teach. Next slide, please. So we already teach to many of the main challenges, as Rachel mentioned, but to help new attorneys adapt to writing in new genres specifically, we can explicitly discuss genres of legal writing in class. So sometimes we might present legal writing as being a very particular way of writing. For example, when we explain the parts of a memo or a trial brief, and then we expect students to hew very closely to the style and format that we teach. Indeed, my own students often sort of struggle with this, and what they're trying to do is emulate the samples that we've given. And so for addressing writing in new genres, we can explain to students that while we're giving one sample or a few types of legal writing in class, legal writing can take many forms, and we must teach students to realize when they have encountered a new genre. It might be relatively obvious. For example, they're at their legal aid office and they need to create a PowerPoint explaining legal analysis for an organizational client or something like that. Or it could be a new genre that they don't realize is somewhat different, like a different style of memo or a different audience for that memo, for example. So we need to teach students how to recognize when they're in a new genre and then decode that new genre. What are the components? What is the style that is expected? To the next bullet, we can also reassure students that the challenges that they encounter in legal writing are very common among most new lawyers. By explaining to students that most new lawyers have a hard time with, say, writing concisely to a discrete audience, we help students anticipate this challenge for themselves and also recognize that they will improve with practice. We do not expect them to be experts by the end of their first year lawyering course, but we are empowering them to keep improving. So students are not alone in these challenges, and they know that these are going to continue being challenges even after they're done with lawyering, but they will be prepared to encounter them. And then we also can talk about how students can improve in these areas beyond that lawyering course by engaging in strategies on the job or in practice. So we'll go to the next slide for that. Next slide, please. Okay, so students can improve their work on the job. We can prepare them to encounter new genres of legal writing and new expectations from their supervisors by explicitly discussing the strategies like those here that students can use. So for example, we know that new attorneys have issues with analysis and conclusion. These were common challenges across genres, and these can be improved with more expertise in the relevant area of law. Experienced attorneys just don't struggle with those big picture issues as much because they've already been working in that area of the law, unlike the new attorney. So to jumpstart that experience, we could suggest that a new attorney read the bedrock cases or treatises, secondary sources in that area of law. So for example, after lawyering, students might go directly to work for a nonprofit that does housing law, and they just have no idea sort of what the bigger picture of housing law is. It's not like they've studied that in their first year doctrinal courses. Maybe there was no lawyering assignment on a housing law issue. And so what they should do is be reading on the bedrock cases and secondary sources in their jurisdiction on that issue. Further, because we also know from our data that there can be often a mismatch between the level of feedback that supervisors think they are providing versus what new attorneys feel they're getting, students could ask their supervisors for more samples and use decoding skills to figure out what their supervisors are looking for. So we could have them ask their supervisors for more than just 1 or 2 samples. Usually I only provide 1 or 2 samples in lawyering. However, now that students are writing in a practical setting, they want a bigger picture view of that genre that's new to them. We even think, given how many informal emails our students are writing, it might feel a little silly for them to ask their supervisor for a sample of a professional email, but actually this could be a really good idea because the students won't know yet what is the expectation for a professional email in that particular setting and around that particular audience. And finally, we can remind our students that if and when they become supervising attorneys themselves, they can think back on the common issues that new attorneys have, like style, concision, analysis, and provide targeted feedback in those areas. Back to you, Rachel.
So that brings us to the end of our presentation. If you have any questions or comments for us, please feel free to send us an email at the email addresses here in blue, and we look forward to hearing from you. Thanks so much for watching, and thanks for your interest.
Thank you.